But first up is the rule of law crisis caused by out-of-control Supreme Court decisions in the last week. We had two decisions come down, one related to the Civil Rights Act of 1964, the Title VII provision that prohibits discrimination because of race and sex and other immutable characteristics. And the Supreme Court was considering the issue as to whether or not being either homosexual or transgendered fit the definition of sex under the law. Now, if you're a common sense type of person like I am, you would recognize that when in 1964 Americans voted this law into place, they understood the definition of sex to be really specific and biological, meaning you can't be discriminated on the basis of being a woman or a man. Now, the Supreme Court, in a majority opinion written by the alleged conservative jurist, Judge Gorsuch, joined by Chief Justice Roberts and the other liberals on the court, not that Roberts is always liberal, he's impossible to pin down, except on political cases like this, obviously. They decided to rewrite this anti-discrimination law. You know, typically laws, well, not typically, under our Constitution, laws are to be changed by the legislative process. Congress is supposed to change the law, and then obviously the president signs it. That's the way our Congress and the executive branch is supposed to work. And for the Supreme Court of the United States to come in really over, was it 50, I guess nearly 60 years after the fact, and decide a law that has been read specifically to not cover gays and transgender, was designed to cover gays and transgender by the very language, is the height of judicial arrogance and legislating. And as I highlighted in our statement about the issue, they undermine the rule of law today. It's been a years-long battle, by the way, by the left to actually change the law legislatively to expand it to include bans on discrimination because of someone's sexual orientation or gender identity. And the reason that hasn't happened is because the consequences of that would be dramatic socially in ways that would be objectionable to many, many Americans. So the Supreme Court today short-circuited the democratic process and rewrote the law without a vote by Congress, but with a vote by unelected judges. I mean, and as I said, it wasn't like Congress didn't know what this issue was about. They were considering it repeatedly. We had filed an amicus curiae brief. That's called a fancy way of calling it a friend of court brief. These are these briefs that groups and sometimes individuals file with courts to help them educate them on issues in the case. And Judicial Watch's brief detailed how Congress repeatedly rejected efforts to amend the law. There were 71 bills over 45 years that attempted to include sexual orientation or gender identity in the definition of sex. And as we wrote, it's singularly unpersuasive after all those bills have failed to argue that these categories were in there all along. Any such statute should be passed by Congress, not ordered by the court. You know, and as Justice Alito warned, today's decision, unless fixed by Congress, and Congress can fix this, and that's a big if they'll do anything, could destroy women's sports, weaken religious freedom and free speech, weaken personal privacy, and cause chaos in the schools. Because just think about this. In many ways, they're undermining the protections of sex by blowing up the definition like the court did. It means that any male wanting to participate in female-related activities that traditionally exclusively have been barred to males, and vice versa, obviously, could be thrown out the window. So male wants to participate in field hockey that's played by females. That can happen. Male wants to participate in, let's say, strength sports that have been that are only limited to women to make up for the difference in the relative strengths of the sexes. What would be the limit on that? Same-sex bathrooms, do they go out the door? Can you prohibit any person from entering any bathroom? Same-sex dorms. Will there be diversity requirements and quotas for people of a minority sexual orientation and transgender status? I mean, in transgender status, as you know, I mean, that's controversial just scientifically. So who are you discriminating against when a male identifies as a female or a female identifies as a male? How is that sex discrimination? You're discriminating against the male because of his sex or because of something other than sex, which is his behavior or inclination. I mean, the court is pricked kind of blow up very complex social debates. And of course, then there's the First Amendment. You know, the First Amendment, you know, it used to be important. It protected your right to your own conscience. So will it be free, religious rights exemptions? If a church disapproves of that conduct and behavior, will they be able to hire people who share their religious worldview? It's all going to have to be litigated. And so, you know, my fear is that, you know, when decisions like this come down the pike, because this vote comes up repeatedly in Congress, and some Republicans hate having to go against the cultural wave in favor of increased rights based on sexual orientation and gender identity. I mean, the gender identity thing, it's almost a totalitarian outlook. People are being attacked and thrown off Twitter and attacked or boycotted because they question some of the underlying assumptions. I mean, practically speaking, is it going to be illegal to have moral objections to these behaviors? Is it going to be illegal? I don't know. I mean, the court admitted that these issues are going to come up, but they don't have to decide those now. So we'll just be litigating this for more. So this judicial activism, this judicial supremacism is just going to lead, under Judge Gorsuch's analysis, to more judicial meddling in the organization of our society, the core issues of biology and sex. I mean, they think the left has told us we have a right to privacy. That all went out the window with this decision. You don't have a right to privacy anymore. You don't. In your thinking, and on core issues related to where you go to the bathroom, you don't even have the right to privacy. That's how crazy this is. That's how crazy this is. And the left is all excited about it, and it just shows you the left doesn't care about the Constitution. I mean, rather than trying to persuade people to change the law, however objectionable, you know, we might disagree. It may not even be constitutional what they plan to do in terms of changing the anti-discrimination law, because, as I said, of the First Amendment issues. You can't statutorily overturn a constitutional amendment. But that being said, that was the process. Instead, you had the process short-circuited by 6 unelected judges. And I tweeted out this issue the other day, and it's really disturbing to see the lack of leadership we're getting from Congress in response to this. In many ways, they're kind of a little bit shell shocked, so I understand that, because no one, or I should say, few people were expecting this. But this is an attack on our Republican form of government. It's an attack on Congress's prerogatives under the Constitution, and frankly, under any fair system of self-government, to do the legislating. And so, I know many of our conservative friends, and, I'm upset about this decision, because we work and work and work to make sure justices that are strict constructionists, originalists get on the bench. And then you have results-oriented jurisprudence like the Gorsuch garbage that came out earlier this week. I mean, Gorsuch, 9 times out of 10, I agree with him. But it's quite obvious he had a social agenda, a political agenda, and he needed to find a way to get it achieved. And he was willing to, break the system to do so. I was joking with someone the other day. I said, I forgot how awful June is, because every June you have all these decisions come down from the Supreme Court, some of which are good and you're relieved by, others of which are assaults on our Republican form of government. And you had this here with the Gorsuch decision. And Congress, of course, has the ability to fix this. What is it that Congress can do? Well, Congress can pass a piece of legislation that says the Supreme Court is wrong. When we wrote sex into the law, we didn't mean what the Supreme Court pretends it means. And it would end there. We've got the significant problem with judicial supremacism. And it's not so much the supremacism, because courts are going to, they've got this awful power. I don't mean awful in the sense of negative, but really under this current model of jurisprudence that too many judges subscribe to, it's really wide ranging and in many ways the final say in how our laws are interpreted and applied, or in some cases like this, even made. But that's not the way it has to be. The founding fathers were brilliant. They came up with a system where you had 3 branches of government, all of which were balanced. They call it the checks and balances. That was the name that scholars came up for. And so each branch was checked and balanced by other branches. So when you had the Supreme Court or the judge or courts going outside their lane, so to speak, or going rogue, you had opportunities to fix it by the executive and legislative branches. The problem now recently is they've refused to do that. Or I shouldn't say they have. Conservatives have refused to do that. So I suspect that, as I said, many Republicans are going to breathe a sigh of relief that they don't have to vote on this. They hate voting on these issues, and now the Supreme Court has taken it off their plate. Same with gay marriage. The Supreme Court redefined gay marriage, or redefined marriage to include same-sex relationships. A radical abrogation of power. Radical. And I mean abrogation of power that resides with the people. Congress did nothing about it. They did absolutely nothing about it. So when the Supreme Court makes a radical redefinition of a statute, or essentially rewrites it, Congress can come in and fix it. Obviously, the president will have to sign a law, but that's the check and balance. So the problem with judicial supremacism is the other branches haven't stepped up to exercise their constitutional prerogatives to restrain the judiciary when it gets out of control. And that's not what the founding fathers intended. So if I were you, I would call Congress up and demand that your elected representatives fix it. Fix it. I mean, one of the cases that was before the court, there was a funeral home director, family-run business, it sounds like, who had an employee who decided that he was going to start dressing as a woman during work hours and showing up to work as a woman. And this man is working with grieving families, and he thought that was inappropriate. And he thought about it and thought about it. It wasn't like he did it lightly. He said, you can't do it. You know, you either have to go or do something else. And now the United States Supreme Court is telling that man, no, you got to do it. Doesn't matter how you run your business. And as I said, these are immutable characteristics that are traditionally protected in civil rights law: sex, race, national origin. I mean, I don't even understand the philosophy. I don't even understand how the law would work given the radical changes in, the radical analysis I hear from the left on these sexual identity issues. They talk about fluidity. What does that mean? It means that you may identify as one sex one period of time and another sex another period of time, or no sex at all. How is it you manage that in terms of anti-discrimination? Don't worry, courts will figure it out. You know, my first reaction to this was, what suckers we are. You thought your vote counted, didn't you? You thought you ran your government. Well, these 6 justices, unelected, appointed for life, they basically told you, go jump in a lake if you think you run your government. It's a terrible assault on our Republican form of government. I don't know, what the administration's going to do. Are they going to push for legislation? Call the White House. Tell them what you think. These Supreme Court decisions happen. They're awful, and no one wants to do anything about them. And in the meantime, as just year after year, our freedom and our rights to self-government fritter away under constant assault. And Justice Gorsuch, I've supported Justice Gorsuch's nomination. I supported Chief Justice Roberts' nomination. I mean, the next time there's a nomination by an allegedly conservative jurist, I mean, the lesson there is maybe everyone just shuts up because you don't know how they're going to vote unless you get explicit promises. The other check on judicial abuse is the impeachment power. Oh, whoa. I'm sure this video is it's going to get censored because I said the word. But that's a check. Congress doesn't want to exercise it. I think they exercised it once or attempted to exercise it once in the 19th century against a judge. Didn't go anywhere, so the thinking is, well, we can't do it. Well, it's not what the Constitution says. I don't have the language in front of me, but one of the founders, pointed to the impeachment power specifically as a check on abuses of power, just like this, by judges. Now, does it mean I think that the judges need to be impeached every time they do something wrong? No. But certainly we can talk about it. We're not allowed to talk about it, though. I mean, I raised this, and I'm not a lawyer, so I go to these conservative legal meetings, and I cause some trouble because I say things that lawyers typically don't say. And I sometimes talk about impeachment for judges. So there are these checks, and it's all fear-based decision-making too often in Congress and the executive branch. So we had this outrageous decision by Justice Gorsuch, signed by 5 other justices, to legislate from the bench, pretending to be textualists by saying, well, sex says what it says, and engaging in pages and pages of sophistry to tell you that you can't believe your lying eyes and what your good sense tells you. The idea that when those individuals in 1964 passed this bill, this is the language they used, just because they had a failure of imagination of how the word would be used, it doesn't mean that it doesn't prohibit us from changing the definition of the word. Terrible arrogance. So, what next? Congress should fix it. I don't know. They're obviously not going to, even impeaching the judges isn't going to change the decision because the decision's out there. It highlights also the importance of getting good nominees to the bench. I don't have any specifically brilliant ideas on how to make sure that, Judge Gorsuch, for instance, who has all indications that he probably could be a good Supreme Court judge, how to make sure that he wouldn't rule this way, or get an assurances that he wouldn't abuse the powers entrusted to him by the American people to impose his personal beliefs on us. So you got to do everything. You just can't rely on the judges to protect you from the crazed left or bad policies. Judge Bork, and I encourage you to go back and read this book, Judge Bork, who's passed away. He had a book called The Tempting of America. And he made the point, and the theory of the book was that, judges are, because of the position they're put in and the sort of deference they're given in our constitutional system, at least currently, there's this awful temptation for them to mistake their personal views for the law. And he called it the tempting of America. And it's something that a liberal jurist can fall into, and frankly, it's something that a conservative jurist could fall into. Now, let me give you an example. Roe versus Wade, in my view, was a terrible decision. It found in the Constitution the right to abortion through the entire 9 months of pregnancy if you can get a doctor to do it. Now, since has been mitigated a little bit by subsequent decisions, but the core ruling is still out there. So those of us who believe in the right to life for unborn children, removing Roe versus Wade doesn't necessarily make those rights enshrined in the Constitution. You arguably would have to change the Constitution to extend the right to life protections, or change state laws' constitutions to extend right to life to protections to the unborn. And I would debate this because I don't know the answer to it, but would it be appropriate for a conservative jurist to read into the Constitution that the right to life must now be applied to unborn human beings? You see, that's what my point is. It works both ways. So we got to be cautious. And, we had six justices attack our Republican form of government. They rewrote civil rights law. It was an exercise of raw judicial power to change the definition of sex. I mean, does it get much worse than that? And legislating from the bench is an abuse of power. And I'm sorry, but, we're worried about the attack on our republic from rioters and looters and the insurrectionists in the streets. And we see this week in the Supreme Court, our republic and our rule of law can be attacked by judicial activists on the bench.